High School District Board meeting. We are reconvening from closed session. The board met from 5:01 to 7 and took no action. Covered a lot of ground. So we are going to start with the Pledge of Allegiance. All right. Well, I'll read it today. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, item number 7, adoption of agenda as presented. Do I have a motion to adopt the agenda?
So moved.
Second. Okay. All in favor? Aye.
Aye.
Sorry, guys. Stuff. All right, do we have any, Rick? Oh, I'm sorry, do we?
No, we do not have to. Oh, I'm sorry. No, item 9 now.
We move on to item 9, and we have one green sheet. Green sheets are for items that are not on tonight's agenda, but we welcome public comment. So if anybody else has anything they want to talk to the board about, feel free to fill in a green sheet. By law, we are not allowed to interact or provide feedback or comment, but we're listening. Our ears are open. We always like to hear from the community, so we're going to welcome Andrew Burrs, who's going to speak. Andrew, welcome.
Thank you.
Thanks for coming tonight.
Thank you.
You've got 3 minutes or so.
I'll try to get through that.
No problem.
Try to open it up. Push the button.
Red light.
Yeah.
Yes, the little guy.
Speaker.
In the middle of
His nose.
Red light.
the.
Good evening. My name is Andrew Burrs. Good evening again. And I am the parent of a 10-year-old special needs child who has a range of special needs, including epilepsy, focal epilepsy. He's on the autism spectrum, and he's a charmer who is very charismatic and loving. He is currently at El Granada in SDC class, and my wife Claudia, to form a little background, have lived on and off the coast for around 20 years, have returned to the coast after 2.5 years in Mexico, and we just wanted to kind of update everyone that our goal in moving back is to form a very progressive, very large, and very active, essentially, advocacy group for special education in the Cabrillo district community. We moved back to Cabrillo district after years away. We had lived in San Francisco, we had lived in Marin County, and we had heard anecdotal nightmare stories about things happening in special education on the coast. Came back, experienced a little of that ourselves, but we were greeted with an extremely positive note when the district hired Holly Wade, who we cannot say enough about. She's impressive, she's talented. Well, it's going to take me about 3 more minutes. And most importantly, she's collaborative and she has vision. And when you put together the kind of leadership, thank you, Jane, the kind of leadership that Holly represents for us, forming this advocacy group and making real change is going to be something that we see as possible. So just to give everyone, this is just to give everyone a heads up. We're looking to put together around 500 families throughout the 7 schools, throughout the district, plus community members, plus general ed parents and families and anyone interested. And I've been meeting myself with stakeholders, I've been meeting with PTO, I've been meeting with the CEF, and one thing, I have just 2 comments I'd like to make. One is communication within this district, between the district and the parents, the district with the district. For such a small space we have, maybe we can work collaboratively to improve just the channels of communication. Email, telephone, Facebook, all of the ways we communicate now. We can be a little tighter as a district on the way we communicate. We post flyers, they post flyers. A lot of people don't read flyers, just want to mention that. And then second is, I've done a lot of analysis of our budget and the data related to our budget. I have a little background in this myself. And I'm under the understanding that structurally, this district is operating in a deficit, and structurally, the way it looks in coming years, we're looking at deficit spending, and that there needs to be some kind of active approach with respect to changing the way in which the money is coming into this district. My understanding is it's like per capita, and this is a problem, blah, blah, blah. I would love more information on that if I could get it, so we can look at ways to find out whether in fact that's going to change, and if it's not going to change, we as a huge advocacy group need to move ahead and go, okay, this is the circumstance, we need to accommodate it, right? Finally, last thing I want to say is, it is really, really time that special education, these special needs children who have had no voice, we've seen it in the Bay Area, we've seen it outside the Bay Area, we've seen it for 2.5 years in Mexico. It is really time to collaboratively, collectively have a voice. We have our leader, and now it's time as a community, as essentially a force, to get this going. I look forward to working with all of you in days ahead. Thank you.
Thanks for speaking tonight. Alrighty, we're going to move on to representative reports. CUTA, Sean, oh, there we go, I didn't see you there. Welcome.
President Papalardo, Superintendent Yuster, board members, and district administration. I missed you last month, not because I don't appreciate and value these meetings, find them interesting. It was my aunt's 87th birthday, so I was out celebrating with great company and great food, so I missed you. But 87, that's my graduation year from high school. Now, Jane can tell you that I'm not great with numbers, right? Even addition can throw me off sometimes, but there are some numbers I like. And I did a little number crunching. 21% of Aunt Mimi's life I've been working here at Cabrillo Unified. So I feel pretty proud about that. But what I really feel proud about in terms of numbers are the numbers that we, as a collaborative group of Cabrillo Unified Teachers Association and the Cabrillo Unified School District, those numbers that we put on the salary schedule and the compensation article 2 years ago in our last negotiation round. Even with the commotion of Pumpkin Festival and homecoming and a change of seasons, summer's over and the winter is here, the discussion on campus is all about the negotiations that are coming up. Teachers have been provided with a survey, and we're looking to that survey to guide our focus of negotiation. And I want you to know that the negotiation team is ready to get to the hard work of collaboration and compromise that was so successful 3 years ago when we were negotiating before. I'm looking forward to that same sense of satisfaction when we sign this deal sometime in 2019. Thank you.
We don't usually comment here, but Sean, I feel it's really important to hear you use the word collaboration, knowing from when I got on the board, and Frey and I were elected with Kirk 8 years ago. That's the opposite of what it was. So thanks to CUTA and all of your energy, and Kathy and your predecessors, to work with our new superintendent and their team to get that kind of outcome.
Well, I want our new, the person who spoke to the public today to know that this is a group of collaborators. And your work might not be easy, but will be willing to make it.
Thank you. CSEA? Is anybody here representing? No? Okay. All right. We are going to move on to, there are no reports, information, or presentations, so we're going to move on to discussion item 12, discuss action on resolution stating intent of Board of Trustees to transition from at-large to by-trustee area election system. Superintendent, this is your item.
Yes, good evening. It is with great pleasure that I introduce San Mateo County Council. We are extremely lucky in this county to be represented by an outstanding group of attorneys known as San Mateo County Council. The reason they are here this evening is that our district received a demand from a law firm in Southern California to change our election system for our governing board members from at-large election to district election. We are not unique. We were not singled out in this. It has been going throughout Southern California and now has moved to Northern. And if all of you in the audience have, and board members, we've all been following our city of Half Moon Bay going through exactly the same drill. So it is with great pleasure that I welcome County Council this evening, and they will explain this further to you.
Thank you very much, Superintendent Euster. I'm Claire Cunningham, Lead Deputy County Counsel, and with me tonight.
Hi, I'm Tim Fox. I'm a Deputy County Counsel.
And we are going to be presenting to you on the California Voting Rights Act and the various issues that are raised by the letter that was received by the district on September 17th, as Superintendent Euster described.
So Claire and I and several others in the County Counsel's office constitute your California Voting Rights Act team. There are a group of us that have been working on related issues and have had this experience in other jurisdictions, school districts and other jurisdictions. But there are also others who will be working in the background as well to assist you as you navigate this process. So I'll be doing the presentation, but there are many others that are behind it. So this is your district. This is the boundary of the Cabrillo Unified School District. As you all know, it extends to the north and in a generally north-south alignment along the coast side out to a boundary that roughly corresponds with the ridge line. And you're elected in an at-large election system. Now, you probably never really thought about what your election system was. It probably just seemed natural to you, but it is a type of election system, one of several that can exist. And it's the most common type for school districts in California. An at-large election system means that the members of the governing board, the Board of Trustees, you all, reside anywhere in the district, and that when your four-year election terms come up, you are subjected to an election where the voters throughout the district, the entire population of the district that is eligible to vote, votes for you or for a person running for your seat. So an at-large election system is kind of like a giant mixing bowl where everybody can live anywhere so long as they're within the jurisdiction, and everybody who lives in the jurisdiction and is an eligible voter gets to vote every time there is an election. So that means essentially on a 5-member board, that you'll have 1 year where you vote for 2 members of the governing board, and then 2 years later you'll vote for 3 members of the governing board. So it'll alternate on a 2-year cycle, and all 5 board members are elected in that way. But that's not the only way it can be done. The California Voting Rights Act is state legislation that has existed since 2001. And superficially, it follows and is modeled on the Federal Voting Rights Act, which was a consequence of the Civil Rights Movement and is probably the more famous of the 2 laws, certainly because of its national application. Generally, the Federal Voting Rights Act is a law that requires that all jurisdictions in the United States utilize voting systems that don't deprive minority voters of their political power. So the federal government has always, in some way, since 1965, been involved in ensuring that local jurisdictions don't operate voting systems that have the effect of depriving racial minority voters of their political power. So California came along and adopted the California Voting Rights Act in 2001. Now, why is it that the state needed to adopt its own law if the federal government was already in this business? Well, in 2001, the law that they adopted essentially made it easier for a plaintiff that wanted to challenge a voting system to force jurisdictions into using a by-district or trustee area election system by essentially eliminating 2 of the 4 tests that were built into federal law. So the federal law would require a plaintiff to show that 4 things were happening. The California Voting Rights Act would only require that 2 of those things were happening before it would be regarded as a violation of the law. So it's a lower bar in California. California wanted to be more progressive and give more plaintiffs more opportunities to bring lawsuits under its law than was available under the federal law. I want to clarify in terminology. Most jurisdictions in California refer to there being essentially 2 large-scale models of election. They call it at-large, which we've discussed, everybody votes for everybody, and by district. By district meaning that the jurisdictions are chopped into smaller sub-jurisdictions with one trustee living in each jurisdiction and only the residents of that smaller area voting in any particular election. The confusion comes about because you are a school district. And it's merely a terminology problem because when you say by district, it sounds like you're talking about the entire district. When the city says it's adopting by district elections, it's somewhat clearer that they're talking about creating a new thing called a district, and that's going to be the entity that votes for a member of the city council. So the habit has been in the school realm where we operate to refer to them as trustee area election systems because that is somewhat clearer than saying at-large versus by district. So I'm going to be talking about at-large systems versus trustee area election systems because that is the system that avoids the ambiguity of the use of the term district in two different contexts. So when I said that there were 4 tests under the federal law, these are the 4 on the left-hand side. Can the protected class constitute a majority of a district? Does the protected class vote as a block? Do the voters who are not in the protected class vote in a block to defeat the preferred candidates of the protected class? And do the totality of the circumstances indicate that race is a factor in elections? To be a prevailing party in a federal lawsuit under the Federal Voting Rights Act, you need to prove all 4 of those elements. The state of California came along and said, let's strike 2 of them, and instead only ask the question of whether the protected class votes as a block, and do the voters who are not in the protected class vote in a block to defeat the preferred candidates of the protected class. So as I said, by eliminating those other 2 factors, they've essentially made it much easier for plaintiffs to prevail when they bring these lawsuits. So what has been the effect of the CVRA in 2001? Well, in fact, at first, nothing. When this law was adopted, there wasn't a lot of attention paid to it in 2001. You probably didn't even start hearing about it until maybe 4 or 5 years ago, if that. But there's been a growing movement on the part of activists, law firms, to bring cases against jurisdictions, school districts, cities, and other jurisdictions to change their voting methodology. And as a result, this really is more of an effect in the past, say, 7 or 8 years than since 2001. 165 school districts have switched to trustee area elections. 28 community college districts have done so. More than 100 cities have done so. The County Board of Supervisors, in fact, it was our County Board of Supervisors that switched most recently because it was the last of the 58 counties in California to still use an at-large system. And that was changed by a charter amendment that was adopted by the voters 4.5 years ago. And 10 water or other special districts are in the process of changing or have changed. And that number is growing all the time. In fact, I guarantee these numbers are out of date just even in the past week. The driving factor is not necessarily governance principles, it's money. And the reason is that because the 2 factors eliminated under the California version of the law make it so much easier for plaintiffs to win these cases, and because it's a civil rights lawsuit, the prevailing plaintiff gets awarded their attorney's fees, the jurisdictions are switching because a threat of litigation is expensive enough to make it worthwhile to voluntarily switch rather than subject themselves to a large award of attorney's fees after trial. And the column to the right shows you examples of jurisdictions that have chosen to fight the demands placed on them to convert to by-district elections or trustee area elections, and the consequences of that decision, which have been rather expensive. So for the most part, the jurisdictions that get faced with the demand to switch decide to switch at an early stage so as to avoid incurring a large attorney's fees bill, both in their own defense and to pay the plaintiffs. So to give you an example of some of the cases that have gone to trial under this law, the city of Palmdale, the city of Santa Clara, and the city of Santa Monica were all subjected to these demands and decided to go to trial on the merits. And Palmdale and Santa Clara lost. Santa Monica merely went to trial in August of this year, and they're still awaiting their decision. Modesto and Palmdale spent about $1.8 million each just on their own defense costs, and the award that they had to pay to the plaintiffs was even higher. And Santa Monica has spent $5 million in its own defense so far, and if it loses, it stands to pay about that amount or perhaps higher to the plaintiffs in the lawsuit. So these are the numbers that we're talking about for larger jurisdictions being faced with demands that they change and a decision in that in those instances to fight the lawsuit. Yes?
The focus of their arguments going back to the two remaining for the state of California, they're just focused on those premises, those rules. that are
Correct.
allowed.
When the cases are litigated, they're litigated on the statistical analysis of whether or not the voters in the jurisdiction get overwhelmed by majority voters. Whether minority voters in the jurisdiction have their voting preferences overwhelmed by racial majority voters. And it's a very complicated statistical analysis, and it doesn't necessarily hinge upon what the outcome of the election was for the jurisdiction that's being sued. So, in other words, it's not solely a question of whether or not the board itself is representative of the community. It is a question of whether or not when the voters vote, their preferences are aligned along racial lines and whether the majority voters overwhelm the minority voters. So the net effect is that essentially the legislature, by adopting this law in 2001, rather than simply mandating that jurisdictions of a particular characteristic or size should convert to trustee area elections by a particular date, it simply said, let's make them all subjected to the potential for a lawsuit, let's put them at risk of a very expensive lawsuit, and let's give them a very short period of time in which to decide what they're going to do about that lawsuit. So the legislature is kind of pushing you in a direction, but rather than actually giving you a path forward that makes sense, they're doing it by incentivizing someone to threaten you with litigation and then seeing how you respond. This is an important point. The only safe harbor that against an allegation that your district's elections violate the Voting Rights Act is to adopt trustee area elections. The law says that if you revert to this position of, okay, we will now go with trustee area elections, you cannot be subjected to a lawsuit under the CVRA that you are operating an election scheme that deprives minority voters of their political power. Okay? So you have received such a demand. You've heard from the superintendent that your board received a letter from a law firm in Malibu, California, indicating that they take the position that your current election methodology of at-large elections violates the California Voting Rights Act and demanding that you change to trustee area elections. The law provides a very specific process that you are to follow when you receive such a demand. Starting on January 1st of 2017, a new elections code section was added that lays out the timeline in very specific terms, and it requires that before anybody can sue you, they have to send you this demand letter. So you can't just be hit with a lawsuit. You have to the plaintiff has to give you advance warning of what their intentions are, which in this case they have done. So the law then puts a 45-day stay, once they've sent the demand letter, on bringing any action in order for your board to meet and discuss whether or not you want to adopt a resolution outlining your intention to transition from at-large elections to district-based elections. Now I want to be very clear here. The 45-day deadline is not for you to convert to by-district elections or trustee area elections. It's merely to adopt a resolution saying that it's your intention to do so.
That's on your agenda for tonight for action, is a resolution of intent.
So no final decision is essentially being made by a resolution of intent. You are simply complying with the law's requirement that in order to buy yourself more time to have this discussion, you're going to indicate your intention to convert to trustee area elections within the 45-day window. Once you've adopted the resolution of intent, it then creates a new 90-day period in which you may meet to perform the other steps of converting in the process. I'll show you a little bit later that you are not the final decision maker with regard to your own elections. There is in fact something called the County Committee on School District Organization, a shadowy organization that meets in Redwood Shores, that oversees the process of not only district boundaries for school districts when there's a territory transfer between them, but also the method of election of school trustees. So you can propose a change, but ultimately it'll be taken to the county committee, and the county committee will decide whether or not to allow the change. And they've seen other processes by school districts that have done exactly this. They know they know why districts ask for this when they do. So, yes,
I'm sorry, have they ever not accepted the proposal brought to them?
not in this county. For a method of election related to this, they deny territory transfers sometimes, they grant territory transfers sometimes. They don't always agree with school boards, but when it comes to this, they have only taken the action in favor of the district's request so far. Okay? So the resolution of intent that's on your agenda for tonight is merely a statement of your intention to proceed down a process of ultimately taking a final action to convert to district-based elections, but it's not a commitment to do so at this point in time.
And the purpose of that resolution is to stay within the safe harbor provisions to avoid being sued in the near term and having to pay expensive attorney's fees.
Right, so adopting the resolution provides that safe harbor. So there are actually two safe harbors that we've talked about so far. There's a 90-day stay of litigation if you adopt the resolution of intent, and that will give us the time where the plaintiff can't sue us while we have this discussion and talk about your district and think about, vision what happens next. And then there's a permanent safe harbor from all civil rights lawsuits over your voting methodology under the CVRA if you conduct your elections based on trustee areas. So it's two different safe harbors, but we're recommending that you avail yourself of both of them. And I've illustrated this with Pillar Point and Princeton. So this is the process. The resolution of intent is the first step, and that's what happens tonight. It starts a 90-day window of time in which the plaintiff is barred from bringing any action for violation of the CVRA. So the lawsuit gets put on hold and the demand letter is put to the side while the district has this discussion. The law requires that you hold 2 initial public hearings once you've adopted a notice of intent. Those public hearings are to obtain community input about the district's communities of interest. We will talk about what that means in a moment. But you're not allowed to put pen to paper and start drawing maps. You're not supposed to panic and start, chopping up your district in ways that make sense to you until you've adopted a listening posture with regard to the community, and you hold 2 public hearings to receive the community's input about what they think the communities of interest are in the district. After those 2 meetings have occurred, and they have to happen within 30 days of each other, so you can't make the process draw out too long, you then instruct your demographer to draw maps as proposals. And they can vary widely, in some cases wildly, from each other. So you will consider the draft maps. You might say, we like this one, but we think you should include this other neighborhood, or maybe move the line here or there. You can have that discussion, and you're gonna hold hearings on the draft maps. Those 2 meetings have to be within 45 days of each other while you discuss and revise the maps. And there are rules about if you're gonna discuss a map, you have to post it a certain number of days in advance on the district's website to make sure that the public is aware of what you're discussing. And then ultimately, you will be asked to adopt a map. The 90-day window that's provided by the law closes on January 9th of 2019. That's not a lot of time. 90 days is 90 days, but it also coincides with the holiday season, and it might be difficult to engage the public at this time of year, so that's a concern that we're going to discuss in just a moment. But the 90-day period where the plaintiff is barred from bringing a lawsuit expires on January 9th. If you adopt a particular map and specify an order of election, which seats go up for election at which times, that's something you're allowed to specify in your resolution. You'll then take it to the county committee, and the county committee will hold a hearing here in your jurisdiction and invite the public to comment. And of course, by that time, the public will have had several opportunities already to comment on the map. But there will be yet another hearing held, and you attend that one as well. And the county committee approves it. That means that by November 2020, none of this, by the way, will affect the 2018 elections. It'll only come into effect in the 2020 elections. And the first by-district elections will be held in 2 trustee areas in November of 2020. Then, because of a quirk of timing, you'll need to redraw the maps by 2021 to reflect the 2020 census data. So you will have gone through this whole process in 2018 because you got a demand letter that happened to be on the eve, essentially, of the expiration of the census data. So you're gonna have to do a bit of a redo in 2021 to adjust for new census data. And then in November 2022, the next by-district elections will be held in the 3 remaining trustee areas. Now, I want to assure you that in 2021, you're not going to have a bunch of different meetings and public hearings, et cetera. It really is going to be only about rebalancing the boundaries of the trustee areas to ensure that they continue to be equal in population. That's the purpose of the adjustment to the census data, to make sure that you're not getting out of whack because of excessive growth in population in one part of your jurisdiction as opposed to another, which is not a particular serious concern on the coast side. So, we are not here to talk about how to draw maps. We're not asking for anything in particular about maps, but we wanted to give you some information about what the process is going to look like so that you undertake it with your eyes open. When a local jurisdiction draws trustee areas, it has to comply with all federal laws about how to draw these maps. So you have to have equal population, that's a requirement of federal law. You have to make sure that the ways in which the boundaries are drawn complies with the Federal Voting Rights Act, which still applies. It's not just California. You've got to comply with both. And you must not have any racial gerrymandering. I want to explain my pronunciation. I learned that very recently. When I was in elementary school, I thought it was gerrymandering. But I'm told that Elbridge Gerry, the man for whom that is named, actually went by Elbridge Gerry. So it's actually gerrymandering. You're not allowed to do it. You're not allowed to draw a boundary that has the effect of overly concentrating a minority population in a way that results in racial isolation in a particular boundary of your trustee areas. But you will have lawyers and demographers who will advise you if that's going to be a problem in a particular proposal. Now, everything on the right side of the slide are simply traditional principles that tend to be used when you draw boundaries. You want to define communities of interest, which is something we're going to talk about in greater depth in a moment. You want them to be as compact as possible. You want it to be reasonable for a candidate for school board to be able to travel within the trustee area and get to know the voting population there, knock on doors, get to know people, meet people. It has to be contiguous, or ideally it's contiguous. You can't really create islands of population and then have one trustee that jumps from island to island. They generally tend to correspond with some kind of visible boundaries. You ideally want to use either a major street or road or a creek or some other thing so that as somebody is canvassing the neighborhood, they know when they're crossing out of their jurisdiction and into somebody else's jurisdiction to make it easier to run for office. You're allowed to draw boundaries that respect voters' past choices. In other words, to draw boundaries in such a way as the currently elected board continues in office or can continue in office, and the voters are given all the same options to vote to re-elect the board if they wish. And you should draw boundaries that plan for some kind of future growth, or in the case of the most recent census data is from 2010. You can adjust it to try to account for any growth that might have occurred since 2010. So those are generally the universe of ideas that go into play when you draw boundaries. Now, I wanted to talk a little bit about sort of the emergency aspect of this, the 90 days. On September 6th of this year, a new law went into effect. There has been some legislation on the California Voting Rights Act recently, which provides that it's possible for a jurisdiction to approach a plaintiff who has sent a demand letter, such as the one that you received, and ask whether the district can have an additional 90 days in order to get time to conduct public outreach, encourage public participation, receive public input. And if you do that, you enter into an agreement that says the district will establish the boundaries at least 6 months before the next general regular election. Now, weirdly enough, your next regular general election is November 2018, so we're going to need to clarify that that we don't need to do that 6 months before that date, because I've already passed that point. But basically, this provides an opportunity to voluntarily extend the time frame in which to conduct this analysis and hold these outreach events and engage the public about these issues. So I used a term on an earlier slide called community of interest. What does community of interest mean? This is really the single largest issue when it comes to creation of trustee areas. What subgroups within your district exist, and what should be done about their existence in order to ensure that they can meaningfully participate in the selection of the governing board? So there are essentially two questions. what is the neighborhood, or for lack of a better word, neighborhood or community of interest? One easy answer would be school attendance areas are a community of interest. That is certainly an available opportunity for school boards to look at school attendance areas as being one kind of basis on which to start building a trustee area. That's an opportunity that exists. Natural neighborhood dividing lines. There are some fairly clear communities, particularly on the mid-coast. El Granada knows that it's different from Montera, knows that it's different from Princeton, knows that it's different from Moss Beach. So these things kind of like, they evolve in neighborhoods, and it's understood that you live in a particular community. Those are also a community of interest. Parks and other major landmarks. One community of interest would be everybody who turns left at the end of 92 and everybody who turns right at the end of 92. Those are logical communities of interest. They have widely disparate experiences at times. And so that would be another basis on which to build these maps. Common issues, activities, or concerns, if there are such in your district that you want to talk about. And even shared demographic characteristics like socioeconomic status or education level, linguistic isolation. These are communities within your school district that, that exist and that might benefit from being provided a geographic region definition that would allow them to elect their own school board member.
And it's particularly important for the board and the community to weigh in and discuss what the communities of interest are, because that's not something that the demographer is going to know just looking at the numbers from the census information. So that's why it's important to have your participation as well as the public participation in discussing what are the communities of interest in developing the maps.
So I've been talking about community of interest, and it may seem logical that the reason to talk about it is to make sure that it winds up being unified. But there's just as strong an argument that the reason to define a community of interest is to divide it. Because some communities would rather have a voice in multiple elections and be a smaller part of two different trustee areas rather than a majority of one trustee area. So part of what you're going to be engaged with the community to discuss is, what do the communities of interest prefer? Would they rather be grouped into a single geographic region? Or would you rather describe the geographic region so that everybody is allowed to be part of two political communities, a particular demographic slice, being able to elect two different members to the board? So, let's talk about one community of interest that's obvious. That's the entire district. So the purple line is the community of interest that exists today. Right now you have an at-large election system. Your community of interest is the entire district. But it was not always so. Cabrillo is actually the consequence of a series of reorganizations of prior existing school districts that go back to 1894. So this is what Cabrillo used to look like, and these are defunct school districts. This is a Half Moon Bay district, this is the Denniston School District, the Montera district, we have the Ferris district, the Tunis district, the Bell district. These are all school districts that existed in 1894, and in 1894 they felt like communities because these were the people that educated each other's children. The Higgins School District doesn't exist anymore, but you can imagine that the folks that live in Higgins Canyon might have thought we should educate ourselves and each other's children and thought of themselves as a community of interest. I'm not suggesting that you can go back to 1894 and use that as the building blocks of the ways in which to think about your community, but I love maps, and it does seem that maps are sometimes a record of what a community thought of itself at the time. So the fact that Purissima was a different community from Half Moon Bay at some ancient point in the past is something that might provide some guidance about natural boundaries that were existing in 1894 that might provide some guidance about where you might draw boundaries today. So this is just an example of one input that you could potentially use to have these discussions. Okay? So these are not maps of your district because I'm not supposed to present to you with maps of your district that show trustee areas that you can draw at this stage of the process. This is the city of Compton to the left. And you'll notice that what they decided to do when they adopted trustee area elections for their city council was to do highly compact districts. This is like straight by the book, let's just create equal population and create, basically quartiles or quintiles of the district. And the only nooks and jogs on the lines are really driven by a desire to create equal population. So they create as many straight lines as they can and just create the most logical geometric district that they can create. This is another example. Glendale Unified School District also did highly compact areas when they drew its boundaries. You'll notice that the areas are big and they are sort of, drawn together. They're not geometrically interesting. They just happen to correspond with roads, et cetera. So this is one way to do it, is to do highly compact areas and just create equal population in all of your districts. But not everybody does that. Sometimes the areas that are drawn are driven by policy concerns that are relevant to the jurisdiction. So this is the city of Pasadena, which has a 7-member city council. When they adopted theirs, some of you may know Pasadena has this stretch, very long road called Colorado Boulevard. It's the old part of town. It's the one they do the Tournament of Roses on. And what they wanted was for every member of the city council to have some responsibility for downtown. They did not want to have a city council where there was one council member that says, I'm the downtown guy, or I'm the downtown woman, you, hands off my downtown. They wanted everybody to feel like they were a stakeholder in the downtown issues. So they drew this, which makes sense to the city of Pasadena. It has these boundaries that all touch on Colorado Boulevard, so you have at least half of the street for a stretch in your jurisdiction if you are on the city council in Pasadena. Meanwhile, the city of South Pasadena had different concerns. They're a very tiny jurisdiction, and they needed to figure out a way to get enough people in their jurisdiction to create 5 trustee areas, or city council members. And they sort of basically drew north-south lines. So really very much the opposite of Pasadena. City of South Pasadena sort of drew their boundaries to go north to south in order to capture what to them made sense in terms of a community of interest. And then Central Unified School District, I believe, is in the Central Valley, and you'll see that it's sort of a style of living where there's a road that runs through town, most of the population is surrounding the road, and then there's this large rural area to the south. And they decided that rather than having a trustee that was going to have a giant rural area with a population equal to 4 tinier trustee areas all drawn in the downtown area, that they were going to make sure every trustee had both urban and rural constituents. And that was the value that they sought to effectuate when they drew their maps. So they drew it so in a way that if you were just looking at this in the newspaper, you would say, what are they doing drawing a district that goes like this? That looks like gerrymandering to me, right? That looks like somebody drew a snake down the middle of 2 other trustee areas. And so to them it made sense because their community said that it made sense, and they wanted to make sure that the person that represented this part of downtown also had some rural folks to which he or she was going to be answerable as an elected official. So these are examples where something other than compactness was the highest value that the agency was optimizing for when it drew its maps. So what is the next discussion? We have some action items on for tonight to start the process. If you so desire to adopt the resolution of intent, we recommend the entire package of what's recommended be adopted so that you can begin this process and start down the path of drawing trustee areas. You can decline to adopt the resolution of intent. That's an available option as well, although it's one that comes with some legal risk. If you want to engage in this discussion with your district and with your constituents, the discussion will unfold as follows. What are the district's neighborhoods? Are they the same as its communities of interest? And are there other communities of interest, perhaps non-geographical ones, that need to be taken into account when the boundaries are drawn for trustee areas? Then the next question is, do those communities of interest want to be together in a single district, or would they rather have multiple representatives on the board? And there's no correct answer to that. It's one that you will have to reflect back that from what you hear from public input and from your own judgment about what's best for your district. And then there'll be some discussions about what other considerations should be considered in drafting maps. So to go back to the timeline, if I can figure out how to go back. Nope, never mind. The timeline that I drew out for you says that there are 2 public hearings that don't necessarily need to be board meetings necessarily. They could be if you want them to be. To simply be an opportunity for the public, once they hear about this process, to come forward and express their views and interests in the ways in which the boundaries might be drawn. And then that input will be given to the demographer, who will draw maps that comply with the law and recommend which of the, it won't be a particular map that will be recommended, but 3 or 4 options, and you might look at them and say, go back to the drawing board, literally, and start over. Or you might say, map number 3 looks really good, but I think you should make some changes here and there, and then that discussion takes place. So public input is phase 1, map drawing is phase 2, adoption of a map, phase 3, County Committee on School District Organization is the last step in that process. Something that's not addressed because it's a highly technical issue, this whole question of whether to convert to district election, or to trustee area elections, under the law has to be put before the voters. So you're going to have an election on the question of how to do the elections. Under the education code, you're supposed to submit to the electorate a measure, shall we convert to by-district elections? There is a waiver process that can be followed if that is something the public express an interest, if there's strong community support for going forward and there doesn't seem to be a strong need to put this question before the voters. The State Board of Education grants these waivers every time they're asked for because they know that the California Voting Rights Act kind of puts you under the gun to get it done. So that's something we can discuss at a later stage, but I just wanted to be clear that when the county committee takes its action, usually what would then happen is somebody puts on a ballot measure that says, are we converting to district elections or not? And then a majority vote carries the day and that becomes the law of the district. But there's this alternative path to go to the State Board of Education and say, you know, we're pretty set on doing this. We've received a demand letter and if the electorate votes no, we're going to get sued. So wouldn't it be better to go with a waiver? And so that's something that we'll explore as we go through this process. So I understand this is the first time you're hearing about a lot of this stuff, and it is certainly an elaborate issue. So if you have questions tonight, or if you want to think about it, and we can come back and have this discussion in the next couple phases. There's no urgency to drawing maps yet. Once you start the 90-day window, and as I suggested, there's a potential for extending it further, there will be time to deliberate about how best to proceed. But I'm available to answer any questions.
Relative to that, I'm sorry, go right ahead.
Okay.
Yeah, sorry.
Just one question. First of all, thank you. That was incredibly informative. And yes, this is the first time we're really diving into this deeply since we just got the letter. And so I think we're, at least speaking for myself, digesting and processing a lot of the information. But I just want to thank you because this was incredibly helpful, the way you systematically went through the context and everything and the recommendations. I have one question which pertains to the criteria that you outlined in the federal versus the state laws. And it sounds like essentially the state law comes down to 2 criteria, which are, is there voting along racial lines, and is the minority vote being overwhelmed by the majority vote? So is the assumption through these recommendations that we probably meet, do we know if we meet those criteria? And if we don't, will we uncover that in the early stages after passing a resolution? And if yes, then do we have the option to change our course? Like if it looks like this is not a well-founded, like if they don't meet the criteria, but they just randomly send a letter.
Right.
What's the path?
Couple answers to that question. I'll try to keep it simple. If during the course of this discernment you decide that this is just the wrong thing to do, you can't be forced by this process to adopt the maps just because you adopted a resolution of intent. So right now, January 9th, 2019 is your drop dead date for adopting maps, or you're subject to a lawsuit. If you decide the lawsuit is preferable than going through this process voluntarily, you can simply vote no on the adoption of a map. That's an available option to you. The question of how best to analyze whether or not those two factors that are provided by the law are in play in your jurisdiction can be analyzed by a statistician. They can go through the voting records and figure out in terms of the racial minorities in your district, how they tend to vote, whether they vote as a block, whether the non-minority voters also vote as a block. The difficulty that we face is the law doesn't specify which elections you're supposed to look at to figure that out. And a plaintiff can argue that any election conducted in this jurisdiction is relevant to the question of whether minority voters get overwhelmed by non-minority voters on the questions on the ballot. So even state and national elections could potentially be used as evidence that minority voters get overwhelmed in this jurisdiction by non-minority voters. And so plaintiffs kind of get to choose what the analysis is going to be, and we would be in a position of saying, that's not the preferred analysis, but the case law hasn't yet developed to a point where there's no court that says, yeah, it's silly to look at the presidential election to figure out whether or not non-minority voters are overwhelming minority voters. Let's look at the school board instead. The legislature did not really specify that, and so plaintiffs get to call the shots.
Pretty much, we can assume that there will be an analysis done that would have us meet that criteria.
It would be fairly easy for a plaintiff to
Find
construct
an
an analysis that shows that minority voters get overwhelmed by non-minority voters.
Could I ask,
Just to clarify, make sure I understand what you said, we could go through this whole process, time and money spent, and then could go to an election, the decision could go, and the voters could say, no, we don't want to do this, and then we would be subject to a lawsuit?
If you don't seek a waiver from the State Board of Education, the ordinary course of the conversion would require going through a path where a ballot measure is put before the voters of the district. Every jurisdiction that I have assisted in this process has deemed it advisable to seek a waiver from the State Board of Education. Both the ones that receive demand letters and the ones that are undertaking the process voluntarily without receiving a demand letter. And the consent agenda of the State Board of Education includes dozens of these statewide, because school districts are getting these demand letters, and the State Board knows full well it's not like putting it before the voters is going to change the California Voting Rights Act. It's not a referendum on whether or not that's a good idea.
Yeah. Wow.
And we would have to seek that waiver during the period post the 45 days from the initial letter, but prior to the 90-day expiration if we didn't get an extension.
The waiver process actually can be on a very different timeline. It should be happening concurrently if that's something you decide to do at an early stage of these discussions. In other words, we'll take care of making sure that you meet all the appropriate deadlines for getting a waiver before the state board in time for your next election, which is really what matters. It doesn't necessarily subject you, not getting the waiver doesn't necessarily subject you to greater legal risk.
Thank you. Any other questions or comments?
Just one last question, so to kind of sum it up, for whether or not this is like a functionally good thing for our community, given the situation that we don't have millions of dollars to spend on a losing court case, which is the likelihood of what would happen based on the precedents. Seems like maybe there's not much of an alternative path forward. And it'd be up to us to try to kind of make the most of it and see the good and try to make it yield the perhaps intended results, or I guess intended results of the law to begin with.
I think that's a fair observation.
And just, we can all plainly speak, the Latino community is so underrepresented, both on the school board and on the city council. I'm not really sure about this path and what it will yield, but there needs to be change in some regard. So I think it's been clear to us, we really don't have much choice relative to what's been filed against us, but hopefully we will get a good outcome for the community and for the Latino community in particular. So we'll see, have that in mind as we proceed. Thank you. All righty, let's see, we're gonna go to 13, communication, board members. Kurt, do you have anything you want to share?
No, I really don't have much to say. I did want to say that the comment regarding the gentleman that spoke under 9, that the board certainly welcomes more inquiry into how schools are funded, how our programs are funded, including special education and special services, because the more people understand the process, which is severely flawed. Special education is massively underfunded by the authorities that make rules what we have to do. More people need to understand that and understand what's done despite the fact that we're incurring debt continuously to meet the needs of everybody, so people get a full, fair and free and appropriate public education. These decisions are made on a daily basis, and it does mean further indebtedness of the district. And so I welcome inquiries such as this person spoke about, that everybody needs to understand how this happened and why we are on the way we are. And hopefully that will help them understand why more funding is needed to help the school districts. Absolutely.
Thank you.
I think the highlight of this month was Monday, seeing the high school band playing at the Pumpkin Way Off. It's just exciting to see our kids in the community, and knowing also we've got a fall musical coming up, and I'm just gonna compliment whatever Lauren's gonna say, but I think those pieces are exciting, and it just kind of knowing that the board is faced with yet another action that's not child-centric just makes my stomach drop. And I really appreciate all of the information provided tonight. It's very thoughtful. And I sat here and noodled, and I brought up like half a dozen different sites that have demographic information pictorially for San Mateo County. So I know there's a lot of information there, but to know exactly where the overlay of the voters against race and the distribution in our COSI. Yeah, this is going to be an interesting few months, and I'm hoping we can continue to pay attention to what needs to be sustainable in our district for the kids while we go through this process.
Okay, Sophie?
Kind of somewhat related, just been thinking a lot about, obviously, I feel almost like the last 2 years, for various reasons, have been a crash course in a lot of the topics that we as a society, I know. Well, I wasn't thinking about me as a milestone, but other national politics, political milestones, and the discussions that have ensued that have really brought to light a lot of the kind of undercurrents about race and socioeconomics and gender and all these various issues pertaining to historically underrepresented and oftentimes marginalized groups. And I appreciate also the comment that came in earlier today thinking about neurodiversity as well, so some just forget about that, and that's as important, I would say, as any other type of diversity. And I'm kind of jumping ahead a little bit because we have an agenda item that I'm really thrilled to see on for today, which is the commemoration of the LGBTQ+ month for October for our district. And I feel like this all ties together because as much as we can continue to honor those differences and celebrate those differences, and it sometimes can seem symbolic, but it, as we had done with the immigration resolution almost 2 years ago, huh? A year and a half ago, something like that, on the same kind of thing where we can kind of just, sometimes it feels like there's a big ship with lots of holes in it. We're constantly like, oh yeah, this week it's, with the confirmation hearings, right? Last week it's like, okay, let's get the gender hole plugged, and then next week it's like it's LGBTQ hole plug, and then we got race, and we got like all these different kind of things. But it's important that we keep doing that because it is a continuous ongoing process. So I appreciate the leadership of the district in maintaining that discussion and bringing that forth and sending kind of the, you know, the top-down directive that these are important things that we don't forget about in the day-to-day hassle of logistics of, you know, all the paperwork that we got to do and all the, you know, chins we got to wipe in the elementary schools and musicals and all that other stuff going on. So thank you for keeping your eyes on the big picture, because I think that diversity and inclusion is something that makes us really strong and is, you know, more important now than ever, and will continue to be so in the future. So thank you.
Thanks, Sophia.
I want to say that I've been really enjoying the process of running for school board again. We ran 4 years ago, but weren't on the ballot, so ran uncontested and didn't actually have a campaign, which at the time was great because we just finished a parcel tax campaign and had done a bond campaign several years before. But this has been a really fun process of articulating again what my educational philosophy is and the values, and being able to reflect back on the last 8 years of the successes that we've had and looking to the next 4 to be accountable for our campaign promises and our commitments to the community moving forward. So it's been a really fun process to work on that. I also want to make a comment. I know the beginning of this year has been hard with some emergencies and stuff that happened at Cunha, and I just want to assure the community that we are taking that all into consideration, preparing for making sure that we have the steps in place to adequately respond in the future. And so I think we look at that as a lesson learned and we move forward in the best ability, and I want to assure everyone that that is what we are doing. So, that's all.
Great, and I wanted to comment about Cunha as well, and just acknowledge it's a stressful time that we live in, right? The access to guns and all the things that have happened in schools are horrific, and every threat, regardless of its size or the age of the individuals involved, needs to be addressed. And this district has been focused on mental health and stress and anxiety management and providing services to the students. It's never enough, and it really takes not just the district but the community to support these kids and communicate and have transparency both in communication from the district as well as within the community. So, and I think, you know, we did some things really well, and I want to commend the staff and administration as we had a circumstance where we had to evacuate. We also know that we have some things that we need to improve on, and we've got a game plan around that, as Freya alluded to. But we'll never be perfect, right? Because these circumstances are so unique in and of themselves every time. But we will be better prepared than we were this time, and we'll continue to look at all the latest trends and use the tools that we need to, both in technology and staff, to help mitigate these kind of situations. So that was all I wanted to share about tonight. So thank you. Student, Lauren, you're up.
Okay. I only have 3 today, so it's kind of short.
You have to have 5. Okay.
Half Moon High School is enjoying one of our favorite months of the year. If you have been around our campus recently, you have probably seen plenty of pumpkins placed on the roofs of our school. Decorating our school with pumpkins is a long-standing tradition held by the students. Our school participated in a mock voting process on Tuesday. All students became informed voters by submitting a ballot that casted their votes for current candidates and measures that are being discussed. Clubs are continuing to convene, and our One of a Kindness campaign is resuming their place from last year. Our first annual Cougar Golf Classic fundraiser took place on September 28th. This was a golf tournament set up in efforts to raise money for a boosters program and provide fun for the community. The first publication of the year for our school newspaper, The Paw Print, was presented in the Half Moon Bay Review. The Paw Print is a student-based organization. We are wrapping up our homecoming week with our assembly and football game tomorrow, and our homecoming dance will be next Saturday in our multi-purpose room. El Granada celebrated International Walk to School Day on Wednesday. 2 of our students, Ella and Preston, were recognized in the Walk to School Day poster contest. Goal-setting conferences were just completed. It was a great week of meeting families and setting goals for our students for the upcoming school year. Our classes go on many terrific field trips. This year, our teachers have scheduled excursions to our beautiful Half Moon Bay Library and learn all about great programs they have for children. Our family engagement team is busy planning our first literacy event scheduled for Halloween. We look forward to letting you know how it goes. Things at CUNA have been very exciting. Our 8th graders completed their historical figure project where they dressed up as important people that helped shape our country. For community service, there were over 2,000 books collected by spirit classes that were provided to kids in need, and the warm coat drive will start next week. Our 6th graders had a blast at Outdoor Ed. They learned a lot about the environment while having a great time. Our Freaky Friday dance will take place next Friday. Kickball intramurals are over and soccer has begun. Super Bowl classes have completed over 20 activities.
Thank you.
Thank you.
The expanse of articles in the hot print was amazing. They wrote just fantastic. So compliments to the staff. Superintendent Easter.
So I also would like to thank the governing board for its remarks about CUNA. I echo them, and thank you all for your support. Thank the community for its support. A reminder, you'll be reading it in a minute or so, but next week we're very pleased that every school within the district will be hosting a safety night presentation talking about our anti-bullying programs and activities going on at each school site. So we welcome, of course, our parents, our staff, but the general community, and we thank the Half Moon Bay Review for helping us publicize this so well. This is not a one-off type meeting. I want to reassure the community. There will be a whole series of meetings about cyberbullying, a number of very critical issues that will continue to take place throughout the course of the school year. We continue to make progress on the communication aspects that we spoke about in the letter that I put to the community. And also the other areas, we will have a Big 5 meeting at the end of this month here in Half Moon Bay, and law enforcement and a number of experts will be here to talk to the community about this protocol which is used throughout San Mateo County and how it impacts the safety of our students at our schools. We're delighted to host this meeting and thrilled to have the community here, and thank you County Council because they assisted us in the setup of this, and County Council has played a pivotal role in working in the safety protocols throughout the districts. And so we are delighted to have that. And then once we do that, we will begin to take the State of the District address out to all of our local sites and communities to begin a conversation about the wonderful things that our schools do, and also some financial discussions with our community as well, so they can get a clearer picture. Just as was mentioned in the comment, we will be responding on financial condition of our district and the challenges that we face, and the wonderful programs and the wonderful students. All of this is not possible without the students and the parents and the families. I've always said this is our not so hidden weapon, is the pure strength of our community and our families. And we really look forward to interacting with our community and having some wonderful, joyful conversations.
Thank you, Jane. All right, we're going to move on to item 14, which is the consent agenda. Do I have a motion to approve the consent agenda?
So moved.
Second, thank you. All in favor?
Aye.
Aye. All right, 5 plus 1. All righty, so we will move on to 15, which is action items. And the first one is we're going to hold a public hearing and adopt resolution number 22-18, statement of assurances for textbook and instruction. Ms. Darnell?
We're going to hold a public hearing and adopt resolution number 2218. This is an annual item that we do regularly, and so we want to make sure that we have already posted the information and notice of public hearing, and we want to make sure that we comply with that.
Okay.
Thank you.
So we're going to open the public hearing. Open the public hearing. Any comments? No comments? Seeing none, we will close the public hearing. And do I have a motion to approve the resolution? Second. Okay. All in favor?
Aye.
Oh, was it resolution? Sorry. Yeah, sorry. It's right.
Aye.
Aye. Aye. All right. There we go. Thanks, Fred.
Motion and who's second?
Yeah.
We're split.
All right. All right, and we have another resolution, 15B. So just if you would bear with me in the electronic document. We, of course, just spoke about this, but it's under you, Jane. If you prefer. Okay.
I'm looking at her. She's
Okay.
looking at me and we're, there you go. Okay, so we just heard from County Council about the fact that if the board wants to take advantage of the safe harbor provision, that this is the resolution that needs to be adopted. So we stop the clock here and we then begin to explore moving forward, but this is an absolutely necessity if the board chooses to move in this direction. So I hereby bring to you the resolution stating the intent to transition from at-large to by trustee.
Do we have a motion to adopt resolution 2318? Second. Sophia seconds. This is a roll call.
Aye.
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 Aye. 5+1. All righty, we'll move on to 15C. Sorry, guys. Got a bit on this. All right, and this is approved proposal for districting services with National Demographics Corporation, NDC.
Yes.
Crystal?
So as presented earlier in County Council's presentation and then just approved in the last action item for the resolution, this journey that we are about to embark on, we will need some assistance with. And so tonight I ask you to approve the proposal for National Demographics Corporation that will guide us through the process of the map drawings and our public hearings and community meetings.
Thank you, Crystal, for that explanation. Do I have a motion to approve the proposal for districting services?
So moved.
Second?
Second.
Thank you. Okay. This is just an approval. All in favor?
Aye.
Aye. Right, 5+1. All right, we're going to move on to 15D, which is adopt resolution 2418 designating October as LGBTQ plus month. And again, bear with me. I'm speaking on this one. And that is Superintendent Euster again. Okay. That's okay.
My apologies. So this board has a history of making statements on behalf of the community when we recognize and celebrate the diversity that makes Cabrillo Unified such a powerful district. The resolution that I place in front of you this evening is in that line of resolutions that we've done before. This one for LGBTQ+. So it is a celebration of the marvelous diversity of our students and our families. It is what makes us a great district, and I believe it is in our community's best interest for us to celebrate this, to celebrate the wonderful contributions that all human beings need to make for this to be a productive society. And the resolution asks not only for recognition of the month, but also asks for our faculty to actively pursue this month and all months. History courses, mathematics, all of the fabulous achievements that the great diversity of this nation and of this world needs in order to overcome many of the challenges that face us. So I ask you please to adopt this resolution.
Very eloquent, Jane. Thank you. Do we have a motion to adopt resolution 24-18? Okay, and a second? I figured you might know. Okay, this is a resolution, so a roll call vote.
Aye.
Aye. Aye. Great.
Just a comment.
Of course, yes, please.
I think it's wonderful that we're adopting this, and I'm always just amazed at how society has changed so much and acceptance. You look at the local movements and how to create a place where we were outwardly accepting these, or California has adopted such a curriculum that we are honoring different folks in our
Well said, thank you. Okay, we will move on to 15E, approve scheduling of a governing board working session on October 23rd. Jane?
Yeah, and actually I need to correct, this is a mislabel, my apologies. We schedule a special board meeting. It turns out it is a working session, but I should have technically the language here, so I would like to correct that. It is the scheduling of a special governing board meeting, and it becomes a working board session. Sorry, I learned my lesson a little late, right as this went to print. But we've had a discussion about the finances of this district and the budget, and the board expressed a desire in our conversations to have stronger conversation, and there is a mechanism available to the governing board where it can interact with the public, still be a board, but interact with the public in not be in violation of the Brown. So it's a freer interaction. The working session allows you to get input from a variety of sources in a much more casual fashion, yet still be a working board together and protected. So the proposal, we have a number of people who would like to speak at that meeting and will be present when a number of dates were brought by, and one of them is TBWB and availability, that the parties were all available on October 23rd. Thus, this special board meeting is being proposed.
Thank you, Jane. Do you have a motion to approve the scheduling of this special meeting?
I move to approve.
Okay, all in favor? Aye. Right, consistent, 5+1. All right, so we're on to 16, future board agenda items. Next month we'll receive a report on summer intervention program. We will appoint new members to the Bond Citizens Oversight Committee. That's very exciting. I know those interviews are going on, and look forward to having a much larger committee than we've had previously. C is discuss construction facilities plan and schedule. D, we will approve single site plan for student achievement, also known as SIPSA. We will receive LCAP update on goal 4, which is student safety, very apropos. Of course, F will approve Cabrillo Unified School District Governing Board policy updates and adopt the proposed revisions as recommended by California School Board Association. We didn't do that this month, but we do that most months. So that's it for the next agenda items, and then we will have future events. Homecoming, October 9th through 12th, high school. Of course, Pumpkin Festival is this weekend. October 15th, community safety meeting, which Jane commented on those next week. That's going to be at Cunha on the 15th. October 16th, staff development day, so minimum day for students. October 16th, also another community safety meeting. This one's at Pillarcitos and Half Moon Bay High School. More safety on the 17th. We'll be at Hatch, El Granada, Farallon, and Kings Mountain. That's going to be a full day. Then G, October 18th, Great California Shakeout Drill, all sites. Earthquake? Yep, that was our next question.
10, 18.
Okay. 10, okay, October 24th, 8th grader high school orientation. Wow, exciting already, that's happening. The 26th through 28th, we'll have the fall play, Peter and the Starcatcher at the high school. The November 5th through 7th, teacher conferences at Pillarcitos. 6th through 8th, parent-teacher conferences at Cunha, which is minimum day for students. And we will be back on November 8th. And we are going to return to closed session, so we'll adjourn the open session. Thanks for all of you for participating and coming tonight. Have a good evening.